Shalom, this is Yahuah Magnified, and I'm back with another informative video. Today's video is titled, If You Agree, Then Do Nothing. But before I tackle this subject, as always, I must state for the record, I'm not a lawyer, I do not practice law, and I do not pretend to. All my videos are for informational and educational purposes only. They're all facts and all truth. Nothing more, nothing less. So with that being said, guys, let's get to it. Okay, but before I go with the subject matter at hand, I need you all to hit that like button. And also, for those who are watching or viewing my channel for the first time, hit that subscribe button and also hit that notification bell, okay? Because in my videos, you will find remedy, all right? You just got to be willing to watch them and pay close attention and understand exactly what's going on as I break these topics down to you guys, okay? So now, again, I titled this video, If You Agree, Then Do Nothing. Why? Because we're going to go over what? This final administrative support order, as it states on the screen, okay? So, now, we're going to go over this order because I just want to show you how powerful consent truly is, okay? So now, as you all can see on the screen, this final administrative support order is coming from where? The state of Florida, Department of Revenue, Child Support Program. So now, that should automatically raise a red flag. Why? Because we know that the state of Florida, Department of Revenue, Child Support Program is in fact a what? Is in fact an administrative agency, okay? No different than any other administrative agency, okay? We also know that the Department of Revenue Child Support Program is in fact underneath the executive branch of government, okay? So, if the Department of Revenue Child Support Program is underneath the executive branch of government, that means that the department lacks authority to enter in an order, okay? Unless one agrees to that order. Okay, so now we're going to find out by reading this final administrative support order, how can one agree to an administrative order? Okay, because everything is done by consent. Now, let's read over the order. So we see the petitioner is who? The state of Florida, Department of Revenue, Child Support Program, and my ox child's mom, who I crossed her name out. But that should also raise a red flag, because now we have the one that's entering the order is also the petitioner. So guess what? You know, if you participate in this case, or then you will automatically be what? In a lose-lose situation, because now you have the Department of Revenue is the trial, the jury, and the judge. Okay, so you automatically lost. As a matter of fact, Florida sends these final administrative support orders out before they even schedule a court hearing, which is a clear violation of due process, and we're going to go over that as well, guys. But as you all can see, they are against my aunt, who is the respondent. The depository number I crossed out, and the case number I crossed out. Okay, so now, let's pick this up at the top where it states Final Administrative Support Order. So now, anybody that's reading this title will automatically believe, because it says Final Administrative Support Order, that one is already considered to be placed on support, right? Wrong. Okay, so we're going to read the paragraph underneath the header so we can see exactly what's going on. And it states, important notice, right? Then it states what? This is only a proposed order at this time. It is not yet in effect. So now, if this is only a proposed order, then why did they label the order or this document as a final administrative support order, when they should have labeled it as a proposed administrative support order? The reason why they labeled it final is to confuse one into reading and believing that this is only a proposed order, because by the time you get down to the bottom, you done read the word final administrative support order so many times that you will simply forget that this is simply a proposed order that's what? Not in effect at this time. Okay, but let's continue. Let's read it again. It states what? Important notice. This is only a proposed order at this time. It is not in effect. If you disagree with this proposed order, right? So it's basically telling you and giving you the option to disagree, okay? So that means if you have an option to disagree, you also have an option to agree, all right? Right, now let's continue on. It states what? Read the notice of rights section above. We're going to also read that as well, guys, to get, just to get better understanding of what's going on and how you guys can, in fact, combat letters like this and fake orders like this when you all receive them, But like I stated before, Yes, this document is dealing with the state of Florida, but as in all my videos, you know, the information is the same and valid in each state, because each state has a child support enforcement agency entering fake administrative orders of support. Okay, but let's continue. Let's pick it up where it says it tells you what to do, right, to request a hearing. Then it states, if you do nothing, we will enter this as a final order. Key words, guys. If you do nothing, we will enter this as a final order. Okay? Like I told you guys, silence is agreement. Okay? Silence is tacit acquiescence. Alright? So, you have, according to this document, they're giving you 3 options. Right? 1, to voluntarily agree. Right? 2, if you can disagree to this order. And the third option is to simply do nothing, which is also what? Voluntarily agreement. All right, but let's continue on. It states what? The Florida Department of Revenue Child Support Program enters this final administrative support order, final order, to establish a support obligation for the child named in paragraph 5. So again, who enters the order, guys? An administrative agency. We know that an administrative agency does not have the judicial authority to enter in any orders. Unless what? Unless one voluntarily consents. And I'm going to prove that as well. But let's continue on. It states, we have considered the financial affidavits we received and or other reliable information about the income of each parent. We have taken into account the child support guidelines and any relevant deviation factors in Section 6130. Florida statutes. In this final order, we refer to Maok as the respondent and Maok's child's mom as the petitioning parent or caregiver if applicable, right? But then let's pick it up right here, guys, where it states finding the facts and conclusions of law. So now we know this is a lie because guess what? An administrative agency cannot find facts and they cannot what? Enter conclusions of law. Why not? Because they are not attorneys and they do not work underneath the judicial department, so they do not have judicial authority to even enter in conclusions of law. Okay? But let's continue on. Let's pick this up at number 1. So basically, they're not conclusions of law. This is basically just findings of allegations. That's all it is. No facts involved, no conclusions of law. It's just all allegations, okay? But let's continue. Number 1. The child support program has subject matter jurisdiction in this proceeding and entered this final order as authorized by Section 409-2563 Florida statute. Okay, so we're going to go over this statute as well so I can show you all how deceptive and how wicked the Florida state statutes really are and how we can combat this and get this remedy. Okay, so now let's go to number 2. Number 2. The child support program is providing Title 4D child support services for Maok's child's mom, the parent of the child named in paragraph 5. Number 3. There is no support order for the child named in paragraph 5. Number 4. DOR has personal jurisdiction over the respondent because he/she was properly served notice in Florida on February 17th, 2022. Number 5, the respondent has a legal duty to contribute to the support of the child named below because the respondent is the child's parent. Alright, with the child's name and the child's date of birth. Then it states, paternity has been legally established for the minor child by affidavit or voluntary acknowledgement. And number 6, the child needs support and the respondent has the ability to provide support as determined by this final order, okay? So now, we know again that numbers 1 through 6 are in fact all allegations, okay? So if they are allegations, then they cannot be facts, okay? But if you do what? If you do nothing, then these findings of facts and conclusion of law will become final and they will send this final administrative support order to the circuit court, and the circuit court will in fact adopt this order as if it was an order of the court. Why? Because your silence became agreement, basically stating that you entered into a contract unaware with the state of Florida Department of Revenue, okay? To further prove that, let's go over, right? It says the Notice of Rights section. So let's go over that Notice of Rights so we can get better understanding of what's going on. Let's go there. Okay, so now, as you all can see on the screen, this is in fact the respondent's Notice of Rights, We're going to go over this just to get better understanding of what's going on, okay? So now, as you all can see at the top, it states what? The Florida Department of Revenue Child Support Program. Then it states issues this proposed administrative support order, proposed order, as authorized by Section 409, 2563, Florida statute. We will, in fact, again, guys, go over that statute right after we go over this document. And again, it states what? Respondent notice of rights. A, if you, the respondent, Ma'ak, agree to the terms of this proposed order, you do not need to do anything. We will issue a final order. Okay, that's the first thing you can do. You can remain silent. Like I was telling you guys, your silence is in fact agreement, and they will take that proposed order, file it to the court before it can become a final order. Once it's in the court as a final order, then it's signed by a judge, and that court adopt this final order as if you guys personally agreed to this order, you know, and you sat down and had a true conversation about this order. When you guys didn't, you just remained silent, and your silence again became agreement. So now let's go to B. B, if you have any questions or want to discuss this proposed order with us informally, contact us at the address or phone number provided. If you ask for an informal decision within 10 days from the issue date of this proposed order, your time to ask for a hearing will be extended until 10 days after we notify you in writing that the informal decision has ended. We will work with you to resolve any concerns you have. So again, option B is if you want to discuss the order with them, then you can simply contact them, and they have to make a decision after you guys had that discussion within 10 days. I do not recommend that. So now let's go to option C. Option C is if you disagree with this proposed order, you may ask for a hearing by filing a written request with the deputy agency clerk at the following address. So now, that should also raise a red flag, because if you disagree with the order, you're not the one applying for child support, so why do you have to request a hearing? You're not the one applying for services. The person who's applying for services should be the ones that's requesting a hearing. But I'm going to go over that as well on why they have you guys request a hearing, because they do everything strategic, you know, for those who are unaware and they can't catch on to the deceptive devices that they're using to trap us, man, you know, to have to pay this thing called child support. But let's continue to the next paragraph. It states what? Your written request must be received no later than 20 days after the issue of this proposed order, unless the time to request a hearing is extended under paragraph B. If you file a request for hearing, you should tell us in writing why you disagree with this proposed order, stating each point of disagreement. Basically, they're saying you need to give us a heads up on why you disagree so we can try to find a way to deceive you and force you to agree, or we can prepare an argument for you in court to make you look a certain way. And it's just that simple, but let's go to the next paragraph. If you file a timely request for a hearing, the Division of Administrative Hearings, DOAH, will mail you a written notice of the date, time, and place of the hearing. If there is a hearing, you will be able to tell your story to an administrative law judge who will decide the case. So now, if you're going before an administrative law judge, we know the administrative law judge is also a part of the administrative agency. So you're still in between a catch-22, okay? I don't recommend that as well. Let's continue. It states what? You are allowed to bring witnesses, present information, argue your case, and ask questions of any witness that testifies. Then the next one states what? If there is a hearing, DOAH may enter a final order. Then the next paragraph says, any hearing will consider issues related to child support. Neither DOR or DOAH has authority in this proceeding to decide issues of divorce, alimony, or contested paternity. Only the circuit court may decide these issues. Why is that, guys? We're going to go over it as well, okay? We're going to go over it. I'm just asking for right now so you all can get a better understanding and try to think ahead of time on why it must go to the circuit court to contest certain things. But let's go there. Then it states what? The next paragraph, if you do not file a timely request for a hearing, you will lose your rights to hearing, and we may render a final order that incorporates the findings of this proposed order. So again, if you do not act in the time frame permitted, then they will proceed forward as if your silence is agreement, and they will enter that proposed order as a final order. Let's continue on. D, if you do not respond timely to this proposed order, we will issue a final order that requires you to provide support. We will mail the final order to you and the petitioning parent or caregiver, if applicable, and file a copy with the clerk of the circuit court. If we or any administrative law judge issues a final order, you have the right to seek judicial review in the district court. Okay, so now you guys see what's going on. So again, like I was telling you guys, if you don't respond back, they will file that order in the circuit court. The circuit court will adopt that order as if it's an order of the court, and the circuit court judge will simply sign off on it. Why? Because he took your silence as agreement, and it's just that simple, guys. Okay, so that's why I titled the video, "If you agree, then do nothing," and it's just that simple. But let's continue. Effect of final order. E. If we issue a final order, we may enforce the support obligations by any lawful means, including, and we already know, such as driver license suspensions, income withholding orders, tax wage garnishments, all the other nonsense that they try to do to force men into comply with their schemes of support, okay? So now, as promised, let's break this thing down even more, and let's go to Section 409, 2563 of the Florida Statutes. Let's go there. Okay, so now, as you all can see, we are in fact coming from the legislator in the state of Florida. The name of the website is titled Online Sunshine. So for all you guys who are in Florida looking for proper information and, looking for the child support codes in your state, then this is the place to go, okay? So now, as promised, let's pick this up at Section 409, 2563, which states what? Administrative establishment of child support obligations, okay? Number 1 is definitions. We're not going to go over the definitions. We're going to go over to number 2, okay? Number 2 is what? Purpose and scope, right? So now let's pick this up at A. A states what? It is not the legislator's intent to limit the jurisdiction of the circuit court to hear and determine issues regarding child support and parenting time. That alone, guys, is remedy, okay? So if the agency is pursuing after you, especially if you're in the state of Florida, right? We know that the only thing the agency is trying to do is what? It's the contract with you guys to get you to do what? To consent. Okay, they need your consent. They need your agreement to proceed forward. That's why I say if you do not agree, just simply tell them you do not agree. And then what? They will say that you petitioned the court for you can get a hearing, right? But no, you simply state that it was never the legislative intent to even have to speak to the child support enforcement agency. The legislative intent was always to deal with the circuit court. Okay, but let's continue on. It states what? Top of the page. This section is intended to provide what? The department with an alternative procedure for establishing child support obligations and establishing a parenting time plan only if what, guys? Only if the parents are in agreement. Okay? It's just that simple. Only if the parents are in agreement to do what? To participate with the agency. Okay? Why? Because they need that agreement to establish what? The contract. And it's just that simple, guys. I keep telling you all, it's done by consent. It's all done by consent. Okay? And they're basically saying if you don't consent to going before the agency, then the agency will petition the court on your behalf, making it seem as though you want to go before the circuit court. And they're doing that for a reason. And we're going to go over that reason as well. But let's continue on. Let's pick this up at the top line. It states, entitled for these cases in a fair and expeditious manner when there is no court order of support, the procedure in this section are effective throughout the state and should be implemented statewide. Okay, so now let's go to I, right? We're going to go to I because I are for those who do not agree to contract with the agency. So now let's go to I. The department shall terminate the administrative proceeding and file an action in circuit court to determine support if, within 20 days after receipt of the initial notice, the parent of whom support is being sought request in writing that the department proceed in circuit court. So now you see how they're trying to switch it? Now they're trying to say once you request in writing that you want to go to before the circuit court, who in fact the legislator intended to hear child support issues, then by you requesting that, then it's making it seem as though you want to go before the circuit court. Okay, so now you somehow become the petitioner, right? Even though they're the ones coming after you and they're the ones that's requesting support, not you. Okay, so I wouldn't recommend that, guys. Okay, but let's continue. Then it states, or states in writing his or her intentions to address issues concerning time sharing or rights to parental contact in court and if within 10 days after receipt of the department's petition and what? Waiver of service. Okay? Oh, what a tangled web we weave. So now, why do they request a waiver of service? Because if you sign a waiver of service because you are going to be known as a petitioner, because now you're asking the court to hear the case because they're going to make it seem as though you're moving to the circuit court, that makes you the petitioner. And if that makes you the petitioner, that means you waive what? Service of process. You waive service of process, then guess what? What? That means you lost your personam jurisdictional challenges. And once you waive your personam jurisdictional challenges, they know they have you. Why? Because they know your remedy is in challenge and personam jurisdiction. And I tell you guys that all the time. I have shown and proved that personam jurisdiction gets you all remedy. Go back and watch the testimonies. Everybody tell you guys the same thing. And I post many testimonies, okay? But let's continue. It states what? Let's continue. Top line. The parent from whom support is being sought signs and returns what? The waiver of service form to the department. Why? Because obviously the department knows you was never properly served, right? And also the department knows what? That if you sign a waiver of service, when you get to court, you cannot challenge personam jurisdiction, which makes you and puts you in a bind that you will not be able to get out of. Why? Because your waiver of service is also agreement to consent. And it's just that simple, guys. So again, that's all I'm going to do for today. All right? If you are in Florida, this is your remedy. Understand what's going on, okay? Also, let's do a quick review of what has taken place. So now, if you're in Florida and they send you a document, or if you're in any state and the child support agency send you a document, right? And they want you to come and participate in their administrative proceedings, right? Simply decline. Why? Because the legislator never intended for a man or a woman to what? To waive their rights in court or to a court dealing with the state agencies, okay? Why? Because that's a clear violation of due process, okay, and separation of powers. But, again, I told you all that what? A man has a right to contract, which also granted by what? The United States Constitution, okay, and the corporate state constitution. So because a man has a right to contract, they try to contract with you guys first. Knowingly, some unaware, okay? So for those who are unaware and don't know what to do next, when they receive that document that says final order, they think it's over. So guess what they do? They remain silent. And once they remain silent, the 20 days pass. Next thing you know, they file an order into the court. That order becomes final. Next thing you know, they're doing what? They're now garnishing your wages and doing everything else that they said they was going to do to what? To collect support. Okay? That's the wicked things that they're doing. But then, if you decide to go to circuit court, in order for you to get into circuit court, you need to file a what? A waiver of service form, right? Once you waive that waiver of service form, then you lose your personam jurisdictional challenges, right? So then you go before the circuit court, and the circuit court does what? Railroad you again. Why? Because now you cannot challenge jurisdiction at all, because you did what? You waived it. Okay? By what? By simply signing, which is also an agreement, because a waiver of services is simply you agreeing to waive services, which is also a contract, so they got you again with that. Okay? Which is another catch-22. Alright? So that's how they get you. Understand the game, guys. Understand what's really going on. Let's get this right wisdom, this right knowledge, and this right understanding. Remedy is here. The right wisdom is here. The right knowledge is here. How else you guys think I'll get these testimonies and these brothers come on here to testify to this truth? The truth will set you free. Study to show that yourselves approved, guys. Okay? So again, that's all I'm going to do for today. Like, share, and subscribe. Do not forget, guys, like, share, and subscribe. And also cop that merch. And with that being said, I say shalom.